on what are currently in here, so we're just going to give just a couple more minutes for people to filter through. In the meanwhile, Counselor, would you just be able to raise your hand just to confirm that you can hear me okay? So I can see there with the raise hand function. Excellent, thank you. A couple more minutes, please. Just one more minute, everyone. Just bear with us. Just want to make sure everybody's got an opportunity to get on here prior to us starting the presentation. My apologies. Just bear with us for another minute or two. All right, everybody. I think at this point we'll get started. Thank you very much for your patience, and thank you very much for joining us tonight. Kind of obviously a different format than what we would typically do. We always like to hold these types of things in person, but given that's not an available option to us at the moment, nor probably won't be for the next little while, we wanted to be sure we provided this opportunity to engage us in a fulsome discussion and hear a little bit of a presentation on this subject. So my name is Matt Bruder, and I'm the Associate Director of Planning and Development at the Town of Lincoln. And co-hosting as well, who's here, is Mr. Mike Barkway, who is our Manager of Municipal Law Enforcement. How it's going to work is we're going to go through the presentation, myself and Mr. Barkway. I would ask that if you have any questions, you hold them until the end. How it works is if you look at the bottom of your screen, of the Zoom screen, you'll see a raise hand function. That's the best way to get our attention. Otherwise, it looks like there's possible to message the entire group, but the raise hand function is what we'll be able to see. And then we'll be able to unmute you, and you can inquire as to whatever you'd like some clarification or have a question on. So as long as we're all good with that, I'll get started. So again, I'm Matt Bruder, and I've been handling this particular subject as it pertains to cannabis for the past little while. We're here tonight for the draft business licensing bylaw and the draft nuisance bylaw that were brought before council a little while ago. So in terms of an agenda, I'll give you a little bit of a preamble in terms of how we got here, what we've done to date, and the overall approach we've been taking to approaching some of the issues that we've had specific to cannabis cultivation and some of the impacts that we've been hearing about and trying to mitigate. So you can go to the next slide, Mike. So again, we're here today to talk about the draft nuisance and business licensing bylaws. Many or a couple of you might be aware there's been a little bit of a history about this. Dating back a while ago now, had some issues at the town where there was quite a few concerns being raised by residents throughout the town with respect to odor of some of these facilities and some of the other impacts that they were experiencing. So staff at the time, there were no regulatory controls at the town level in place, as in many municipalities at the time. So what we did was we had an interim control bylaw put in place. And what that did was temporarily freeze all potential development pertaining to cannabis cultivation, so we could undertake a study to look at some options to add some regulatory authority to address some of these concerns that we've been hearing about. So the first step for that was to undertake a review of our zoning bylaw to come up with some policies there and some provisions that would establish things like setbacks, things like minimum parcel size, kind of from a granular level, which would address all new development associated with cannabis cultivation. So we did that, and we also amended our official plan kind of along the same vein. We had an extensive public outreach process for that, lots of comments, very well attended, and we did successfully bring them forward. Now, one thing to note with these regulations is that they address operations that are going to be new. They don't address some of the ones that are already in existence that we were hearing concerns about. So the process kind of evolved from there. And what we really ended up on was a multi-pronged approach that started with that, but moved further into where we are now, which is a public nuisance and business licensing bylaws that we've developed with the intention that they can apply not just to new cannabis cultivation developments, but also those already there, and allow us to add some provisions and some mitigation requirements for some of the impacts that are being experienced. So this dates back to last year when we initially brought the drafts before council. There's been a little bit of a lag, obviously, just because, like I said, with consultation, difficult as it is under the virtual setting. Here we are now, so happy to be here and talk a little bit more about it. Next slide. So as I mentioned, we've been reaching out to our residents, to the community throughout our whole overall approach to this particular issue. Had some open houses previously where we heard about a variety of impacts, the biggest one being odor and air quality for those residents in relative proximity to some of these operations, affecting how they enjoyed their property. We heard about kind of the difference between designated growers versus commercial growers. The commercial growers, they have more stringent criteria from Health Canada that they have to adhere to. Now, I'm not saying that they're completely void of any potential issues, but really what seemed to be the issue was a lot of the designated growers growing for medicinal purposes. Unfortunately, with those types of operations, Health Canada doesn't have the same stringent regulatory framework that they do with the commercial grows. So that was really a distinction that came out throughout the process to date. Another thing we heard about too was retrofits. You know, well, how can an effective odor mitigation system be installed when, you know, the building wasn't really built for that type of crop production or that type of cultivation in the first place? Some people they've been raising the issue for a little while, wanted us to get something. That's what we've been working on. Next slide, Mike. So a couple of other things just with respect to enforcement too, and how we can address these existing operations. And, you know, going further than zoning and official plan land use controls, what else did we have at our disposal? Again, why we're here today. So that's where some of our initial controls came in, with our setbacks, our minimum distance separation between facilities. We want to make sure that we subject them to site plan control as well. So a lot of these things came out of that process. But again, wanting to focus more on what's before us now, which is kind of the next step. Next slide. So just some other impacts that we heard about with real estate values, and even a safety aspect too. You know, cross-contamination to adjacent crops on farm fields, that was a concern as well. Go ahead, next slide. So I think I've covered most of these. These are kind of, we're getting a little granular into what we've already put in place. So this is already there, this was approved, and now we've moved on from there to our draft bylaws before us tonight. Just some more of our provisions. If anybody had any questions on those, we can certainly answer them, but I won't. So just a quick to rehash some of the different licenses. You know, we've got our commercial growers, which I explained, kind of more stringent criteria from Health Canada. We've got a personal production license, also by Health Canada, and then your designated growers, which can grow on behalf of other patients for medicinal purposes as well, which have much less in the way of controls. So just a little bit on the personal production license. It's based on what the dosage could be prescribed by a doctor. It could average over 400 plants, which is actually quite high. So we want to make sure we captured that as well in our regulatory framework. And then when you get into designated growing for other people, it gets much higher and could fill a greenhouse or greenhouses potentially of plants. And we've seen these operations. There's multiple ones that have been in existence throughout the town. So with that, I'm going to pass on the rest of the presentation to Mr. Barkway, who can explain the drafts and what we're proposing to put in place.
Thanks, Matt. Hi, everybody. Bear with me, it's my first one. So the public nuisance bylaw that is in its draft stage right now, as Matt spoke to earlier with the zoning and the official plan, this is part of the multi-pronged approach to try to mitigate the problems that have in the concerns that have been raised before in regards to the cannabis cultivation. It's going to apply regulations to the cannabis industry while mitigating the problems to the neighboring properties. It gives us some enforcement guidelines for the officers that work out of municipal law enforcement, otherwise known as bylaw, to act on complaints and do some assessment in regards to lighting or odor abatement for neighboring properties and residents, and then work through the legislation to try and gain compliance with the entity that's doing it. And there's also going to be other sections in the public nuisance bylaw that are unrelated to what we're focusing on this evening. In part 2 of the public nuisance bylaw, it sets out the restrictions in regards to lighting, which is a big concern that was echoed many times over at the public information sessions that have been held already, the open houses. So it sets out that no person shall cause, or every owner or occupier shall ensure, and that's in regards to the lighting from the cultivation of cannabis plants on the lands. So that goes to the owner or the occupier, but also to the people that are working there. So it helps cover off both those areas with that. And it's opened it up enough where it says so as to be or cause a nuisance to any person or public in general. So that helps the officers with it being a little more open for their assessment abilities. The outdoor lighting and indoor lighting from the cultivation that can be seen from outdoors is meant to be operated with the barrier or have barriers in place so to block that direct illumination from interfering with neighboring residents or premises as well. As well, in regards to the odors, no person or every owner or occupier will permit the emission of an odor from the cultivation to be cause or known to cause a nuisance to any person or to the public in general. So again, goes to the owner operator or to the person that's working there. These provisions allows the owner or the licensee to conduct their operation under the Health Canada license, but it requires them to ensure that there's no public nuisance impact, which we want to be sure that businesses are allowed to operate, but within some sort of measure or control, which is the idea of this. Now, it doesn't specify how to minimize the impacts, because that's how they that's up to the owner, the operator, the licensee to do that, but gives them the flexibility to try to come up with solutions to gain the compliance. But this gives them a framework for doing it. So under enforcement for sections 11 and 13 of the bylaw, so it's identifies it can be enforced by an officer, which is important so that it's not just a police officer or a Health Canada official. It can be an officer. So that would include the municipal law enforcement officers, and it includes the ability to have inspections. That costs associated will be collected and added onto the tax rolls. And then there's offenses and penalties that can be against the person. Those are the lesser amounts, 5,000 to 10,000, or to corporations, which would be the higher amounts, 50,000 to 100,000. And it's also specified in there that each day or part of the day where there's a continuation of the contravention, that's identified as a separate offense, which then means there's a separate charge or a separate fine that goes against that. So it's not just an ongoing thing. Each one's looked at individually. So people are asking how it's going to be enforced or what would be taking place. So we did this screen just to help people understand that. Much like a lot of other bylaw complaints or investigations that go on, it'll be based on a complaint from a neighboring property in relation generally to the odor or the lighting on the property, and the expectation of being able to enjoy your property without that nuisance. So an officer will be assigned that call, and they will attend in the area and make some determinations, but then there'll be multiple visits back to that property to determine what the impact is, how much of an impact it is, the severity of it, and the frequency of it as well. Depending on different conditions, environmental is a big one. It can change that, wind conditions for odor, or day versus night for the lighting. So the officer is going to be tasked with repeat attendance, and that's to make sure that they properly record any of the corroborating evidence for the allegation of the nuisance itself. And then if it's determined there's a violation, they have the authority to issue an order to comply to the property, to eliminate the contravention, so to stop it, and then hopefully gain compliance by the order to comply in regards to the nuisance itself, and or permitting it to continue. So in that, you'll see that the officers that are assigned and involved, it's going to be both proactive and reactive in the monitoring. So they'll be determined different days of the week or hours of the day that they will be attending. And that can be gathered through the time of the investigation, through the complaints that are brought in from the people that make the complaints. And it empowers the officer to make that order to comply, which gives the authorization to get that nuisance stopped and correct or mitigate the problem so that we don't have that anymore. So it's dimming of lighting shades, dimming, removing of the lighting, filtration systems in regards to the odor, many different things. And again, we're not setting this is what you have to have. It's leaving it open to the owners, the operators, to seek remedy their way. But this gives them, like I said before, the framework to go through it. So it authorized the officer to enter onto the land at reasonable times. That's common within the Municipal Act, that it has to be within a reasonable time frame for the purpose of the inspection. And the inspection the officer can require the production of documentation, or providing documents so they can be copied and inspected at another time, or they can work with conjunction of a specialist or an expert with knowledge, so they can bring somebody with them at the time of the inspection in order to determine what all is being made. And that could be somebody from Health Canada, that could be somebody with odor control, or somebody more well-versed with lighting and the different conditions and the effects and how it can be mitigated. Unless anybody has questions about that so far, I'll go into the business licensing. So, and I should probably have checked right away. Can everybody hear me okay? I see Mr. McPherson, Councilman McPherson's hand. There's some. Go ahead, Councillor McPherson. You had a question?
Can you hear me all right?
Yes.
So thanks, Matt and Mike for that presentation. And I guess a question I would have is there a number of visits that would be required to then determine that there is an infraction here to the bylaw, or is there a time period put on the complaint so that the reaction is measured? And then following up on the question, what is how long does the owner get to react to the infraction?
Okay, thank you for the question. I will answer both as best I can. There is no time frame or number of visits there's no restriction on that. And my suggestion would be that the more visits, the better, because it corroborates what the concerns are of the neighboring residences. That being said, it's to be done. It's to be expedited, so it's not going to. It should be for something for lighting or odor. It shouldn't be something that carries on for a month, but there should be frequented visits over the span of a week or 2 weeks at different times of the day to determine if it's an ongoing thing, if there's actually happening, in fact. In regards to the order, if there is an order that's put in place, I believe there is a time frame. I think the minimum is 14 days, I believe. So that would be the minimum time frame that the person or the owner, the licensee would have in order to mitigate the problem based on the order that's issued. Does that answer your question, Councillor?
Very good. No, that's excellent, Mike. You know, I just want to get kind of an idea of what is the process that a bylaw officer would go through, and and I know that these some of these offenses only happen at certain times of the year, and that if we were to spend a month at it, there's a lot of nuisance that's happening in that month. If you see where I'm going with this, so a week, or so is perfect, and then 2 weeks to respond is pretty tight. That's a pretty tight response time, but good. Thank you.
And I see there's a hand raised by Joyce Chen. Hi, Joyce. Do you have a question?
Yes, hi, good evening. My question is in relationships. This slide that has, I guess you were talking about how it was being enforced through complaints from, say, neighboring property. If they were to complain, let's say about odor, how does the odor get measured? Is there a sort of a tool that's being used to measure that, or is there, a certain level in terms of measuring odor?
That's a great question. Thank you very much for that. At this point, there's nothing in place that specifies that there's a device to be used to measure the odors. So that would be based on the assessment by the officers that go for the attendance and the frequency of the attendance as well. Does that answer your question? I couldn't hear the first part of what you were saying. I hope there wasn't more to that.
No, that's it was pretty much just how they would determine whether that odor was significant enough.
Okay, thank you for the question.
Can I just add one thing, Mike?
Yes.
Yeah, we also want to make sure, nuisance has a different meaning to different people with respect to certain odors and whatnot too. So there is a level of discretion for the officer built in. Well, that's one of the reasons why it's structured the way it is. I just wanted to add.
Thanks, Matt. Okay, I'm going to move forward then into the business licensing bylaw at this point. So again, this is another prong in the fork for the multi-pronged approach to dealing with the cannabis cultivation. So along with the public nuisance bylaw, which we just spoke about, the zoning bylaw and the official plan. So this is, again, another tool for us to ensure that there's appropriate mechanisms in place for new cannabis cultivation facilities. And the business licensing bylaw is structured so that other license requirements can be added. So as on a move forward basis, that can be done. Section 2 is the requirement for a license to be for a business to be licensed, and Section 3 is specific to the cannabis cultivation. So there's obviously a process that would be involved in applying for the business license, and there are things that would be required. So the application would be the first process. That would be what would start the ball rolling for this. And that would affect inspections. There'd be a listing of the responsibilities of the licensee with respect to the operation and the maintenance. There's requirements in the application process for proof of liability insurance, the Health Canada license, identifying the producer's name, identifying the corporation officers that are listed. And there's also in the process a refusal of license and appeal provisions. And there's also a revocation of license and fees that are attached to it and applied. So in regards to the process for making the application, would be the form that would be completed and the fee payment made. The documentation would include, there's more to it than this, but the Health Canada license, like I spoke about, there'd be a background check, proof of liability insurance, the producer's name, the corporate officers identified, proof of odor mitigation, records of the installation of that system and maintenance. The town would then undertake inspections of the property for verification of what's been put into the application. And then the application would be processed with any conditions or issues for abatement for odor or lighting or what have you being identified at that point. And then this license is something that would be renewed yearly. And that gives us the opportunity to make sure that everything is still in place. And like any other municipal bylaw, there's penalty and fines that would be associated to it underneath the Provincial Offences Act. So what we would have to do with this is, if it's approved by council, then staff would apply to the Ministry of the Attorney General to make application for charges or fines to be issued without a court appearance. So then it would be a set fine, basically, is what some people coin the term as. Matt, do you want to go into this, or do you want me just to cover this off?
You can go ahead, Mike.
Okay. So moving forward, then the next steps, we would evaluate and consider all the input received to date, including any input from tonight, revise the bylaws on reflection as needed. We would then bring forth the recommendation report for council approval. And once that, if it's approved, then for the business licensing bylaw, we would then apply, like I just spoke to, the Attorney General for the fines without a court appearance. And then we would establish the internal measures needed for processing and implementation. So staffing and equipment and everything else that we would need in order to make sure that we can then apply what we have just gone through and done. With that, I think we have come to the end of the formal presentation. And so I will leave it open now for questions from anybody as we move forward. Councillor McPherson, your hand is up. Did you have a new question?
All right, I'm back. Thank you, Mike. So just a comment first, and then maybe a question. And for those that are here, this is really bylaws focused at the existing grow operations. We had limited ability to really kind of control the existing cannabis grow operations out there. Is that the way you would look at this, Mike?
Yes. Yes.
Okay. Now, on specific to the business licensing piece. So this is This is a lot of information that this business is going to be asked to submit. And, they've got their Health Canada license. Let's assume that. How effective are we in, do you think we will be in basically enforcing on them what we're asking for? Um, and having the penalty, if you will, effective enough to get them to comply.
So I'll jump in here, Counselor, and apologies. I've been brought to my awareness now that my audio isn't very good, so apologies for that. Hopefully, you can hear me okay. But it's obviously our objective is to actively enforce. We require these pieces of information to issue the license. If they don't have a license, they're not to operate once we bring this in place. And there's opportunities there for, if they continue not to comply and not obtain a license, then that would be a recurring theme too. So we could escalate, Mr. Barkley can correct me, but we could escalate charges, we could escalate actions we take as the time goes on as well. So there would be continually increased incentive for them to comply. So I would say, we've got an effective approach here.
Okay, that's good to hear. That's, I think that's, there are certainly a lot of situations out there that these two bylaws will certainly be new pieces in the toolkit, if you will, that we have been waiting for now for some time. Happy to see them, and really looking for them to get moved through and really get ready for this summer, I would say. So thanks to you, Mike, and to Matt for leading this through, and yeah, it's going to be good to have these.
Thank you very much, Councillor. I appreciate that. I'll just leave it open if there's any other questions. I would like to clarify, I don't want to speak out of turn, but I hope everybody recognizes that it's not the town's approach that we are against cannabis cultivation. It's just that we're looking at, as has been explained, some measure of control and regulation in that part of the industry to mitigate issues for their surrounding neighbors, which is what precipitated this whole thing a couple of years ago. So we're not against the businesses, we're not against corporations doing stuff. We just want to have some regulation there in place to help so that the enjoyment of everybody else isn't affected by that. And I see there's a question, Joyce Chen.
Hi, I just wanted to, I guess, clarify in terms of the business licensing, whether that only applies to commercial and also the personal and designated medical growers, and it doesn't apply to, say, the personal growers in a residential.
So I believe are you talking about the personal grown residential, like the 4 plants for household thing?
Yes.
Yeah, that's correct. We're not able to apply it to that, but the nuisance bylaw would still have some application there potentially.
Okay, so you would just still also require, say, a personal grower that's growing for medical purposes to apply for this business license?
Yeah, that's right. The way we've defined cannabis cultivation, we've said medicinal and non-medicinal. acknowledging the fact, like we said before, some of these personal grows can still be upwards of 400 plants. So, you know, we still require that level of mitigation. So yes, it would, that's the goal.
Okay. Thank you.
Floor is still open if anybody else has any questions they'd like to ask. Okay, I don't see any more. Like I said, I appreciate everybody joining us. It's a little bit of a different setting, but hopefully you were able to take away the information that you were seeking tonight. And if you did have any other questions, we'll give another minute or two, but if there's any other questions, you could follow up with Mr. Barkley or myself directly as well at any time. Maybe we'll give one last minute. If anybody's got anything on their mind, let us know. Okay, I think in that case, I don't see any hands going up. So like I said, please feel free to reach out to us, but we've reached the extent of what our agenda was and what we wanted to convey today. So thanks everybody for joining us again. And I hope you have a pleasant rest of the evening.